Hi, good afternoon. Welcome to the Carr Center. My name is Sharmila Murthy, and I'm really glad for you all to be here today. And today we're going to really be talking about why a human right to water and sanitation. And I titled this in part because it's both from a normative standpoint for me that there seems to be value in articulating something like water and sanitation as a human right. But yet I think as an empirical matter there's a real question about, is there really value to articulating water and sanitation as a human right? And we're going to come back to this question several times throughout the talk. So just in terms of a quick overview, starting off with what is thinking about the value of a human rights articulation, going through both questions of, very briefly, morality, enforcement, and judiciability, the nature of rights, and I want to kind of quickly move through this piece and then touch on the status of under international law with a real focus on how it is that I saw the privatization issue playing into what happened at the UN General Assembly and then the Human Rights Council. And then I'm hoping to focus the bulk of this talk on this last question about if, as we're going to see, under human rights law, human rights have historically been considered neutral on questions of political economy, questions of service provision. But then the question is, how are they relevant, and why is it that the human right to water was such a rallying call for anti-privatization activists? And I think we're going to be able to look at this drawing on some empirical work done that in the literature that I looked at, and really focusing on what I think are two really contentious issues around financial sustainability and efficiency. And then finally concluding with a thinking forward about maybe what might be the value then of this human rights articulation, what is their relevance, and I want to come back to this idea of human rights as guideposts for regulation and monitoring. So first, very briefly, the human rights system really came about in the wake of World War II, after the atrocities of the Holocaust, and in many ways codified some existing norms around prohibitions against slavery, but also articulated a series of new values. And when we think about human rights, in some ways I think we often think about morality as being grounded in our religious traditions and philosophical traditions. I think that those influence human rights, but that there's also a real sense of dignity, and that this is really a core value. And now when we're going to be thinking about water and sanitation, just the dignity of being able to live a life where you're not spending hours a day carrying huge amounts of water on your back, walking far distances, or the indignity of having to defecate in the open in places that are going to be creating public health hazards. These are the kinds of concepts that I want to have in the backdrop as we're going through today's talk. So, about what the human right to water and sanitation even means. It's not about having a glass of water in your hand for everybody right now. Really, it's a question of a right to access. You hear this language of entitlement in the literature, but we're going to see that the entitlement in the context of economic and social rights does not necessarily mean now. It's really about looking at how resources are allocated over time to ensure the progressive realization so that one day everybody can have a dignified life where they're having easy access to water and sanitation. And that the criteria, there's several different formulations. This one comes from comment 15 that we're going to see it's one of the seminal documents that we're going to talk about in a second. But this formulation of availability, quality, accessibility is one that is very similar to many other economic and social rights. So if you look at the human rights literature, you see the way food or housing or other kinds of rights are framed. It's in the same kind of framework. So let's stop for a second and think about a concrete example of judicial enforceability, because this next section we're going to be talking a little bit about what does it mean to even recognize under international domestic law something like the right to water and sanitation. And this is an example from South Africa, and I know Laura is from South Africa, and it's a very well-known example in the water field because it was a case involving prepaid water meters. And South Africa is unique in that in 1996, when it adopted its new constitution, enshrined a whole host of economic and social rights in its constitution. And from the standpoint of the judicial world, it's really been at the forefront of trying to say, how do we actually think about these issues? And to the dismay of the people who actually brought this case, the court did not actually rule how they had hoped. And let me just give you a quick backdrop. South Africa has what is known as a free basic water policy, and it was legislatively done coming out of a mandate from its constitution. And as part of that, everybody had access to essentially 6,000 liters per household per month, which broke down, approximately people were saying, to about 25 liters per person a day, which is, if you look at sort of WHO criteria, is really minimal accessibility. In order to try and improve collections and reduce what is known in the industry as non-revenue water, they began to install, they noticed that this one district in Soweto, Firi, had really high figures of unaccounted for water. And so began to install these prepaid water meters as as a way of trying to ensure greater financial sustainability. So the idea is that every household, you get a certain amount of free water initially, and then when that ran out, you would have to pay additional credits in order to get additional water. There was a really tragic incident where a fire happened in a house and a mother didn't have water in order to put out the fire. A couple of children died. And as a result, people really became outraged. And so they brought this case to the court, and initially the lower courts had actually said, essentially I'm going to sort of run through this quite quickly, but essentially said 25 liters is not enough. Prepaid water meters violate our constitution. We need to have 50 liters, not have prepaid water meters. It goes up to the Court of Appeals. There's a question around, well, actually it should be 42 liters. So now you have the judiciary in a point where they are trying to determine what's the exact amount. The Constitutional Court ultimately takes a position that I think we see as in line with what courts around the world that are adjudicating these issues are doing. They're really looking under a standard of reasonableness or proportionality. And so what the Supreme Court says, following a very seminal case, Grootboom, had said, yes, we recognize these rights, but the standard that we are judging is one of progressive realization. And that is the standard that actually, it's interesting because South Africa's standard is very similar to the standard under international law, which is essentially that maximum available resources need to be used to ensure the progressive realization of rights. And so what the court does is it says the legislature's under a continuing obligation to be revising its policy. We're not really in a position to be intervening and saying it should be 25 liters or 42 liters or 50 liters. That's really out of our purview. And that what recognizing the right means is shining a cold, bright light on the legislature's activities and the regulatory activities and ensuring that there's judicial scrutiny. And so although we could debate about the merits of whether or not this was the right decision or not, I want to say that even at a minimal amount, when we think about enforceability of economic and social and cultural rights, South Africa, and we could talk about examples from India or from Israel, where we see courts adjudicating these rights, but not necessarily in the way that you say, yes, today you get this glass of water and I'm the court, I'm saying that. It's really about, once again, providing a level of heightened scrutiny at how the other branches are allocating their resources. So it's kind of just emphasizing the point that I think in this context, when we see international human rights language incorporated into domestic context, we see human rights in some ways as a form of procedural justice. And when we look internationally, we just talked about this language of progressive realization. I want to just take a second and put up the actual Article 2 from the International Covenant on Economic, Social, and Cultural Rights, and give you a second to look at that. So the real key features here are around taking steps, using maximum available resources to achieving progressively the full realization of rights. And this is often just shorthanded as progressive realization, and is frankly one of the key distinctions between economic, social, cultural rights and civil and political rights that we're going to come back to. And I think it's worth saying when we talk about recognizing the right to water and sanitation under international law, whether we're talking about a national constitution like South Africa, or we're talking about an international legal document like the International Covenant, we're not saying water and sanitation gets priority over everything else. We actually have to say that these were all, the language was all rights. And so the covenant covers everything from right to just work conditions, right to organize, right to social security, right to education, right to enjoy cultural life and the benefits of scientific advancement, the right to health, right to an adequate standard of living, which is meant to be all encompassing, but specifically talks about housing and food and clothing, and that water and sanitation is now considered part and parcel of this panoply of rights. And I think that this is really important when we're thinking about, from the standpoint of where legal obligations meet policy and economic priorities, that we need to be thinking not just in isolation about these issues, but how do they fit all together. I think something else that's worth pointing out is that the mechanism of enforcement under international law is one that's a little bit tricky. And in part because that standard of progressive realization is a pretty hard standard in order to hold a state to an account. Recently, just a few years ago, there was an optional protocol passed to that covenant which gave a private right of action to individuals to actually bring a complaint before the committee that is responsible for monitoring and overseeing that covenant. And I think this is, we've yet to see how that's going to play out, but it's once again one of the key distinctions between the covenant on economic, social, and cultural rights and on civil and political rights, where you see the enforcement language is slightly different, where under civil and political rights it's around respecting and ensuring that these rights exist. There's already a mechanism for bringing complaints in place. But I want to spend a moment and just talk a little bit about positive and negative rights, in part because I find that in talking with people, there's often a conflation, a misconception that recognizing water and sanitation as a human right somehow means that it's only a positive obligation, and thus it is less meaningful or has less value than so-called negative rights like civil and political rights. And I think that the easy way of thinking about this, that actually both kinds of rights have both positive and negative aspects. And I think to illustrate that by an example, if you think about the right to be free from unjust detention or arbitrary arrest, that requires a significant investment of resources by the state. It's not simply the state undertaking or respecting a negative right by not putting you in prison. It also ensures that there's adequate police training, that you have courts, that you have advocates in place, and that you have prisons that have safe and fair conditions. So really we see this language in particular in the economic and social rights realm, but I think even more broadly that the framework is really one of this kind of tripartite typologies. It's how it's often called in the literature, around protecting, respecting, and fulfilling rights, where protecting is really the state protecting the rights and entitlements of individuals from the actions of third parties. Respect in the sense that this is sort of your negative rights obligation, ensuring that the state is not doing something infringing on your rights, and then fulfill is ensuring that they exist. So in the water sector, this might be, protect might mean ensuring that you don't have industry polluting your water. Fulfill might be ensuring that there is taps in place, and respect might be ensuring that you don't have arbitrary cutoffs in terms of interference. So this is just kind of a really quick overview of just what do we mean by the nature of these rights. So if we kind of move along and think about, I've already alluded to the fact that this is a recently recognized right under international law, and I want to just take you briefly through the legal basis, but once again with a real eye to this privatization question that we're going to be driving towards. So when the human rights instruments were first codified in the mid part of the 20th century, water was not explicitly mentioned in any of those. And I think that there's various reasons why that might be the case. Some would argue that there's some evidence that it was introduced under part of that right to an adequate standard of living. Others say it's so inherent in a right to life, of course it's not going to be, of course you don't need to specifically say that water is a right. But when you look at, I mean, part of why the legal basis here is really a question of how we think about international law being built up, and you can see elements of it in conventions, like the Convention on the Elimination of Discrimination Against Women, or the Convention on the Rights of the Child, that's CEDAW and CRC at the first, or the Geneva Convention, where we see that prisoners of war have the right to be given access to water. I mean, sort of these basic principles. So we see that water, and to a certain degree sanitation, is recognized in certain instruments. It's not until 2002, however, that the committee that was created to monitor and oversee the implementation of this covenant, the International Economic, Social, and Cultural Rights, so it's a mouthful, issued a comment known as Comment 15, which, if any of you, I mean, if you're at all familiar with this literature, you hear Comment 15 come up a lot. And it's essentially the first time that the committee says water is inextricably related to the right to health and to the right to an adequate standard of living, and it then also traces the legal basis looking at those other instruments that we just talked about, CEDAW, CRC, etc. In 2000, so that was 2002. Just a couple of years ago in 2010, Bolivia introduces a resolution to the United Nations General Assembly with, and the original resolution says that it seeks to declare water and sanitation a human right. Now there's a couple of things that we need to think about that. What's interesting is when it is orally amended on the floor to remove the language declare and instead say recognize, in part because this was not about the General Assembly declaring or creating new rights, but rather recognizing rights that already existed in international instruments, and this is really an interpretation that brings that out. In addition, what's interesting is that the resolution passes and has 122 countries in favor, but 41 abstaining. And so anyway, you can't read that, it's too small, but if you just can imagine what might be some of the countries that would be abstaining. So you have, I want to focus actually on the US and Canada, because I think that the comments that they give in front of the General Assembly are really interesting, because it's not in fact, their comments are not in fact that they are opposed to this idea wholesale. Rather, the comments that they give suggest that they are supporting the work in Geneva. There's this reference to, we don't think this resolution in New York has been fair, it's been introduced in a transparent manner. We support the work that's going on in Geneva. What had been happening in Geneva is that the Human Rights Council had appointed an independent expert to examine the legal obligations associated with improving access to water and sanitation. Notably, not using the language human right to safe drinking water and sanitation, kind of a different legal obligations associated with improving access. And one of the key reports that she had issued was on the question of the role of private actors. And in human rights parlance, we often use the language non-state actors. And non-state actors often means, is often intended to mean anybody who's not the state, i.e. the private sector. It could also mean communities, NGOs, language isn't always precise, but And the key thing that I thought was really interesting is if you kind of read between the lines of the comments that they're giving as to why they're abstaining, is they say, number one, we don't understand the scope of this resolution, because the resolution that had been introduced by Bolivia and the other countries didn't actually explicitly tie the right to the right to an adequate standard of living and a right to health. It didn't. It sort of just said we recognize or declare and then recognize this right. And then number two, it said nothing on the question of delegation to non-state actors. And so when you actually see this coming up before the Human Rights Council, just a couple of months later, there's a consensus decision. And I think the reason that we see a consensus decision coming out of the Human Rights Council on a resolution that's recognizing, once again, a human right to safe drinking water and sanitation, I think, is because you now have some much more clarity around the scope, i.e. framing it within the context of the international covenant much more explicitly, and number two, being much more clear that states are responsible for realizing the human rights obligations, but that does not mean that they have to actually provide the services themselves. And I think what's really interesting about this is because most of you probably know privatization has been such an incredibly contentious issue, in particular in the water sector. And I think if we just sort of take a step back and think about why that has been, we kind of have to understand a little bit more about the broader context of trends in economic development. So beginning in the 80s and much more in the 1990s, there was a big push towards private sector involvement in really in all aspects of basic services. So electricity, power, a variety of things. And water was really seen as sort of the last frontier. There were a couple of very notable failures in privatization, and we're going to talk about a couple of them. But Cochabamba, Bolivia, comes to mind as with the water wars. But examples also from where agreements went bad from other parts of Bolivia, Argentina, Tanzania, half of Manila. Different parts of the world were experiencing protests. And I think what's interesting is the language of human rights is picked up by the kind of so-called water warriors or anti-privatization activists. And I think for many of them, they've been quite disappointed, frankly, in the recognition that, well, human rights, if the human right to water doesn't mean anti-privatization, what does it mean? And interestingly, have noted that many private water companies have actually embraced the idea of a human right to water. And if you look at their statements on their websites, whether you're talking about, Veolia or Pepsi, have recognized the right to water, and in some ways, I think, see themselves positioned to help fulfill that need. But one of the things that's interesting about this is that if you actually look at the history of human rights, as I alluded to at the very beginning, historically, human rights have never been equated with a particular form of service delivery. And this idea of having that human rights equates with anti-privatization it's an argument that I repeatedly engage with even today with people that are coming from different perspectives, because there is this conflation that happens in the popular media. And I put these sort of comics up there in part because you can even trace, I think, the history of the founding of these two covenants, on civil and political rights and economic and social and cultural rights, actually back to a divide between the East and West in the mid part of the 20th century, where there was a real concern about, does recognizing economic and social and cultural rights mean state-provided services? And if you look at all of the various legal interpretations, and there's various quotes from even an interesting quote from somebody from the U.S. State Department from back in the 50s, it's clear this is not the case. But there's always kind of been a little bit of this backdrop and this tension, and so what we saw the Human Rights Council, the work of the now Special Rapporteur, the work of the Human Rights Council is in some ways not new. It's really repeating an idea that has been around since the founding of the system. And I think it gets to this, once again, this notion of all human rights are interrelated, indivisible, and interdependent, and that there's really no distinction in theory between the civil and political side and the economic, social, and cultural rights side. And once again, here's the Special Rapporteur who, in this 2009 report, was very explicit about this, that human rights are neutral vis-a-vis economic models. So if we've kind of gone through that history, really I think that the kind of where the conversation gets interesting is why. Why were these tensions? Why do these tensions exist? And then if human rights are neutral on this question, how are they relevant? So I think we need to take a step back and ask, when we say the word privatization, what do we really mean? And I think that privatization is often, there's kind of three different ways that the word privatization comes up, and I'm only going to focus on one of them. Number one is the kind of what we've been talking about, I think, thus far, the delegation of a municipality or a municipal utility to a big water company to be providing services through a network. That's really what we're going to be focusing on today, and frankly, it's somewhere only between 5 and 10% of all, it's probably closer to 5% of actually all water utilities are actually operated in the private sector. And even when we say that, I mean, I see the look of surprise. I mean, it's such a huge topic that you would think it'd be higher, right? The other thing is that when we say privatization, we don't actually mean usually the wholesale transfer of assets. And so there's only really a couple of examples around the world where that was the case. Mostly people point to UK or Chile where there was actually a wholesale sale of everything. Normally, there's some kind of what we might consider private-public partnership, private sector involvement, whether you're talking about a concession contract, a lease affirmage, a build, operate, transfer. I mean, depending on how the agreement is structured, there's different language. So we've just talked about one category. The other two categories that I want to point out that I'm actually not going to focus on today is the bottled water industry or conflicts with other kinds of businesses. Because I think you see in disputes with Coke or with Perrier or Poland Springs, you once again see the language of the human right to water coming up. Interesting questions, but a slightly different set of topics, so I want to put that aside. I think the third thing when we talk about private is to realize that in many parts of the world, and I know places that many of you have worked in, private doesn't actually mean these formal services. It means your water tanker that's coming to fill up your tank. It means the small-scale vendor who's selling you bottled water or bags of water. And so, there's some statistics that suggest something like 50% of Africans rely on these kinds of informal private water services, and something like a quarter of Latin Americans do. And here we're talking about water. And I want to be clear that although some of the things that we're going to be talking about today do deal with sanitation, really water has been the volatile issue, I think in part because of sort of the people's beliefs and relationship with water. So I'm going to probably mainly just be using the word water. What does the evidence show? I think we're going to be looking at a couple of examples in detail, but in general, if you look at a variety of the analyses that have been done from the empirical work, including some done by the World Bank and other scholars, the evidence is mixed. I mean, I don't think you might find case studies that are successful one way, case studies that are successful the other way, but almost everybody comes back to the same point that the devil is in the details. It really matters how these agreements are structured, what the regulatory system is in place, and that's really the point that I want to be focusing on, of where I see the relevance of human rights principles. And then finally, we touched on this a little bit about why a rise in the private sector. I mean, I think it was in part driven by a belief that this would lead to greater efficiency gains, greater financial sustainability, perhaps deal with questions of corruption, lack of competence. But then I think part of it was also, it's interesting to me that because I think about these things and I use the language human rights, people often say, well, that's very value-laden. Aren't you presuming values into the equation? What I want to suggest is that even in some of the sort of push to the private sector, there are values that are in place. And some people say that's sort of the neoliberal philosophy, but there are values around driving towards prioritizing financial sustainability and efficiency and other things above other priorities. And that's a choice. And that's, as there are different public policy options. But I just want to suggest that as we go through this, to not just assume that one is a neutral way of doing things and one is a value-ridden way of doing things. So I said we're going to talk about two things. The first is financial sustainability, and then the second is efficiency. So we're first going to walk through financial sustainability and specifically looking at tensions with affordability. And I use the word affordability because although the best known example from South Africa is a free basic water policy, if you looked at the criteria around the human right to water and sanitation, you don't see the word free. You see the word affordable. And I think that this is really a key piece. What does it really mean to be affordable? And I actually think this is probably the most challenging of all issues, which is how do you really ensure that these services are affordable to all? And as we're going to see, oftentimes it's the poorest of the poor that are paying the highest prices because they are not able to get access to the formal networked services. They're relying on those small-scale vendors. We come to an example. I want to start with the most famous of all examples, which is the Cochabamba water war example. And I'll just briefly, in case you're not familiar with the facts, just kind of briefly give you a quick overview. Cochabamba was the third largest city in Bolivia, and in the late 1990s the country as a whole had begun to determine whether or not it could enter into private sector concession arrangements with private water companies, and they did in El Alto and La Paz, which we're going to talk about that example in a minute. But in Cochabamba, they did in 1999. And largely because of a hike in tariffs, but for a couple of other reasons, there was massive protests. And basically within 6 months, the company was kicked out. And in this, you hear once again this language around the human right to water. Water cannot be a commodity, it must be a right. And even if we just think about that language, we're actually talking about two different things. And in some ways, this is almost like crossing streets, because the language of a commodity is really one that comes from economics, and it's really that a good must be non-rivalrous and non-excludable. And if you think about what those mean, if we both are sharing this pool of water and I consume a lot of it, it is rivalrous. My consumption of it is affecting your use of it. And it is excludable because if you put some kind of cover over it, I can't access it. So these are not, I think even when we see this language, it's not that they don't relate, but we see rights language being used in places where people coming at it, as I said, from an economic standpoint would say, in some ways it's apples and oranges. One of the challenges, before we go walk through the Cochabamba example, I want to just talk really briefly about why it is that privatization or private sector involvement in the water sector is particularly challenging. And I think if you look at the evidence now, a lot of experts are saying it's much more challenging than the power sector or other sectors, in part because they use the word lumpy, that usually something like 2/3 of all costs are in the upfront infrastructure, putting the pipes and networks in place, that you have to pay for treatment, for leaks, for metering, that it's not cheap to actually provide people water and sanitation to your house with a tap. There are costs involved. And so when we turn to Cochabamba and think about what was the problem, one of the biggest problems there was that a huge fraction of the community did not have access to networked water and sanitation. And the other thing was that the country was facing a severe, the city was facing an impending water scarcity, and it was looking at ways that it could improve the water supply. And so, as part of the bid with the private sector, it actually had asked for tenders that would include this huge project known as the Miniscuni Municipal Project that involved constructing a dam, tunneling through a mountain, I mean, something that required a huge amount of costs. And in fact, the World Bank had done a feasibility study and determined that a different project called the Carr-Ryan Project was more financially feasible, but the city, and I think that there's some question here about the mayor maybe not having the interest of the city in mind, because the Miniscuni project would have apparently carried water closer to the property that he owned, had actually pushed forward for this project. So when we think about the privatization question, so at the same time that the city is looking to engage the private sector, it's looking to use financing to improve the infrastructure, to undertake a huge investment project. The way the contract was structured, it also guaranteed, I think, a 16% rate of return. And so the way that the financing was done, you could almost guarantee that tariffs were going to increase. And I think it's worth remembering that many of us that have the luxury of having piped water and sanitation, that infrastructure was often put in place with subsidies and with financing that spread the costs over large amounts of time and over large numbers of people, so through municipal bonds or other kinds of ways of financing. And that with this big push to financial sustainability, you really see a rise to the language of full cost recovery, i.e., we need to ensure that all of the costs that we're investing now can be recovered. And I think if you look at the details of especially some of these disastrous experiments, you see that they were put in a way that were requiring such a high tariff increase immediately and not really thinking about the fact that historically these costs have been spread over a large number of people and a large number of time. This didn't happen in Cochabamba, but it's worth also mentioning that this whole idea of tapping into the private sector's financial capital is a very attractive idea, but once again, it really depends on how the deal is structured and who is bearing the risk, and even in fact, in what currency is the debt held. And I think if you could look at a place like Manila, there was really an example of a posit, there's two sides, east and west, and the side that didn't do well had 90% of the debt, and it was in a foreign currency. And so when the Asian financial crisis hit, it was impossible to really get out of that situation. And so these are ultimately costs that will be borne by the government, ultimately by the users. Another key thing about that's really, I think, unique to Bolivia, but perhaps in other parts of the world, is that you also had communities that had a history of managing water as a commons, or that were relying on their own private sources of water, like digging their own wells. And I think with what was interesting that happened in Cochabamba was that when the government had allowed the concessionaire to come in, and it also gave them permission to actually put meters on wells that people had put in themselves. So if you wanted to look at sort of a classic case of what not to do, and also to roll this out in a way that really didn't have the buy-in of the local community, this is it. And there's a whole host of other sort of political factors that were happening in terms of coca farmers joining in and being concerned about some other programs and seeing that this was an issue that was kind of aligned with them. There's kind of a host of other political issues that were happening. But I do think this question of sort of the commons is an interesting one because, frankly, I think the human rights framework that we're going to come back to doesn't necessarily provide a lot of room. It's really about individuals and the state, and thinking about collective forms of management that might actually be quite effective without the state. So I just put that as a thought for future. We've already talked a little bit about this, but just the fact that if you've got if you've got, a lot of people that are reliant on informal vendors, they are most likely spending a larger fraction of their income purchasing clean water in one form or another, that may be of questionable quality as well. And I think that there's some interesting work, there's interesting argument and some evidence to support that in certain places, trying to actually raise tariffs is actually a pro-poor policy, because you are trying to ensure that you have infrastructure expansion into places that are currently not served by the network. And that the people that are facing, I mean, once again, this is not meant to be a blanket statement, but rather to really is very context specific. But in many parts of the world, people have historically been able to rely on subsidized rates, and they're not paying, their tariffs are not the full cost. It's really what's the operational cost, not the cost of having to lay all the pipe work, which is now being placed on these people. We can get into questions of, like, you know, the literature is full of questions around what kinds of policy mechanisms really make sense. Do you want to have a rising block tariff where you are trying to basically have very minimal or very low payment pricing for basically sort of minimal amounts of water, and as people consume more, the rate goes up? So in many parts of the world, this is seen as a very pro-poor strategy. In certain parts of the world, it's also been argued that if you have small-scale vendors that are filling up their tanker trucks using a municipal tap, well, guess what? To fill this up, they're paying at the highest block rate tariff, which is then being passed on to individuals. So once again, these are really complicated issues, but I think the real driving point is that when we think about trying to expand infrastructure to the core and really try to realize a human right to water, that this question of affordability looms large, and that there is a tension with this drive to financial sustainability and full cost recovery if it's done in a way that doesn't really take into account all of these nuances. I would also just say that there's an interesting tension here that we don't really have time to go into, but with property. Because in many parts of the world, you have people living in informal settlements. They don't really have legal title to where they're living. And if you look at the idea of a human right to water and sanitation, is that people should have an amount of basic services commensurate with human dignity, regardless of whether or not they're living on land that they own. And this is a real tension in many parts of the world, because governments do not want to be extending services to places that where people don't necessarily own the land as a way of legitimizing their claims. This is also an issue that comes up in, say, certain indigenous communities where, once again, there's tensions on the underlying land. But I think that the idea, these are questions that need to be sort of grappled with and wrestled with within a national context, but that the idea of human rights is really that at a fundamental minimum, we want, as a matter of dignity, we don't want people to have to be getting their water from cracks in a pipe and having to defecate in the open, because that just doesn't seem commensurate with how we would want, the kind of world we'd want to live in. So that was kind of a quick run through of some of the tensions between trying to realize this idea of affordability and the drive towards financial sustainability. I want to kind of go through the same run through looking at efficiency. And what do we really mean by efficiency? The literature is full of examples of the need to reduce your non-revenue water, which can mean everything from your physical losses to ensuring that people pay bills, and cutting costs, which often means reducing the number of employees so that you have a greater amount of water produced per employee. These are often the common metrics that are used to determine whether or not a utility is actually operating efficiently. And sometimes there can be tensions depending on what factors you are prioritizing. And so if you give a quick example from Atlanta, which an example where a concession contract had actually led to this steep reduction in numbers of people, and a real drive towards trying to meet the numbers led to a huge rise in the number of complaints and to boil water notices because water was coming out of the tap brown. And so this is not to say that you cannot have an efficient utility that would also ensure that the water coming out was safe and clean and acceptable and obviously affordable, but that we have to think about what are really the priorities that are being set in a concession contract or in another kind of private arrangement, and that if you don't actually have some kind of regulation in place, you cannot assume that the private profit motive is going to lead to an efficient outcome. Because frankly, it's a lot more efficient to just raise tariffs or cut employees than it is to make very cumbersome, labor-intensive and costly improvements to infrastructure that might actually lead to service improvements. The other thing that's often overlooked, I think, when we look at the examples of private-public partnerships as being kind of the best way forward, is we're actually thinking about transaction costs. In the water and sanitation sector in particular, there's a lot of imperfect information because pipes are underground. You don't actually know the lay of the land. In addition, there's often a real pressure to renegotiate. And so the examples that you look at internationally, it's often when utilities or municipalities are in poor financial shape that all of a sudden they're looking to privatize. And it's in that situation where they don't actually have really the regulatory capacity. They don't necessarily have the ability to do the kind of monitoring and regulating that you'd want to have in place. And so you can have a real push to renegotiate, enter into very long contracts. At the same time, from the private investor's standpoint, they don't want to invest all that money in the infrastructure if they're not going to have some kind of time to actually meet those returns. So this is a real tension. And then there is, without a doubt, lack of competition. And once again, water is a natural monopoly because, once again, the piping, you can really, once it's put in place, you're not going to have multiple competitors for it. And that even if we go back to that Cochabamba example, another key factor that I neglected to mention was that that private company was the only bidder. So it was actually a consortium of a variety of companies, but it was the only bidder that was in place. And so once again, we need to think about, are we really pushing towards these kinds of arrangements, even if it doesn't actually make practical sense. Anyway, just to emphasize, a few pictures to emphasize the nature of the challenges of getting access to good information. We're coming soon to the sort of the gist, kind of the kind of concluding remarks that I want to make. But before we get there, I put up this picture of a cherry because I think there's a challenge around when you drive towards efficiency, cherry picking the best places. And this is a tension in some ways with human rights because if you think about it, traditional kind of cost-benefit analysis, the kinds of policy things that we normally read about, it's really about looking at what makes sense for the majority. Kind of, does 51%, does this make sense? And human rights comes from a different standpoint. It actually looks at the 100% and the marginalized and the vulnerable communities. And once again, depending on how a contract is structured, are you allowing investments to only be made in the easiest places to make them, to meet numbers? Or actually, are you thinking about trying to ensure that you are getting the investments in different parts of the community that may be harder to get to? And here, I think the example from El Alto, Bolivia is a good one, because the concessionaire there had actually indicated that it had exceeded the contractual targets, but that it had done so when some scholars had done some really interesting analysis that basically showed that they were talking about densification of existing networks. So there was already kind of your primary and secondary pipes. They were putting on sort of the household connections. That's the easiest part to make. And they were not defining the service area as including the expanding informal settlement. So once again, this is really just about, once again, thinking about when we are reviewing information or reviewing case studies of successes, are we really asking questions and thinking about the values that are in place? And is was the contract written, or are the targets being interpreted in a way that is kind of allowing prioritization of the easy to get places and neglecting some of the harder to reach places. So what does this mean from the standpoint of human rights? I've kind of mentioned that language a little bit throughout, and I think, you know, it's a really interesting question to me empirically, one that I hope to kind of look at in more detail in the future is, when you describe something like water and sanitation as a human right, does it empirically improve the situation? The theory is that by empowering people and framing, using the rights language, you are entitling people to seek redress. And that redress could come in the form of courts, it could come in the form of protest, but then in theory, you are not only relying on the government to do monitoring and enforcement, but that you're empowering individuals to play a role in that enforcement. I mentioned earlier this protect, respect, fulfill framework. I think that, you know, and what I want to suggest to you now is really, this is sort of my thinking about why this might be relevant, and that I hope to examine more empirically in the future, is that if we go back to this kind of three-part obligations of protect, respect, fulfill, I think to the extent that when you are delegating, when a municipality is delegating to a private company, a non-state actor, to the extent that it is having that private actor fulfill its obligations, there's an inverse relationship, and that there's a greater need to protect in the form of regulation and monitoring. And here, you know, I don't mean to suggest a whole lot of bureaucracy and a whole lot of red tape. And I think that there is some really interesting ways that, whether it's through different kinds of incentive structures or talking about shared value, that there may be different ways of getting to this. But I think that it's important to realize that you cannot just delegate to a third party and hands off. A challenge is that, from the human rights standpoint, is that it's very much a state-oriented model. And so if you have things like corruption, or if you have just sort of a bad governance structure, it is challenging to put that much faith in the government. And I think what's interesting is that comment 15, when it originally, one of the earlier drafts actually called for deferral of privatization until there were sufficient regulatory systems in place. And that actually didn't make it into the final language, I think in part because of this trying to maintain this historic neutrality, but it's a good point. John Ruggie, who we are fortunate to have here as a professor at the Kennedy School, was the UN Special Representative on Business and Human Rights, and has done some very interesting work and was very successful in getting the Human Rights Council to pass guiding principles on business and human rights, which is a similar framework: protect, respect, remedy. Protect is oriented to the government again, but this is about corporations respecting human rights, and then ensuring, this is both to states and corporations, ensuring that there's adequate remedies. And I think here, this is where it gets really interesting, which is when you have a state that may not be in a position to be doing, you know, sort of perfect model state, what's the role of the private actor here? And is there, for example, when you're executing agreements, entering into these private-public partnerships, into concession agreements, into BOTs, what are really the values that are in place in that contract? And if you think about the respecting of human rights, does it mean then that some of the common language, the norms that are getting codified into the language, can include things that respond to human rights around ensuring that everyone has access to available amounts of water, that it's easily accessible, that it's affordable, that it's of good quality, that it's acceptable to folks, and that do the values around non-discrimination and transparency and accountability that you hear in the good governance literature, but that when you frame it with this kind of additional benefit of having individuals also playing a role as ensuring that these norms are really upheld, is there value in that? And I think, finally, these are some issues that the Human Rights Council resolution had actually touched on in the 2010 resolution in terms of asking states to engage with non-state actors and to ensure that they contribute to realizing the human right to water and sanitation, integrating human rights into already existing impact assessments, ensuring that there are grievance-based mechanisms. But I think that there's another layer here, which is really thinking about how those contracts are negotiated and the values that are inherent in them. So with that, kind of a long introduction really into this issue. And just to kind of summarize, we started, if you recall, at the very beginning as sort of from a more moral standpoint, why human rights, and then looked at some of the issues around judicial enforceability and progressive realization, the nature of rights and some of the often common misconceptions with civil and political rights. We then looked at how I think privatization played out in the actual recognition of the right at the General Assembly and the Human Rights Council resolution. And then we, in the last part, really examined went through a couple of different case studies, but with a real focus on potential tensions with financial sustainability and efficiency, and this idea of human rights as being more than just clogging up the courts with more cases, but really about a set of common norms and values that can actually influence the way that private-public arrangements are made. So with that, I'd say thank you, and would love your questions.
So the Washington consensus is dying, which is a good thing, which is where all those privatization problems came from, World Bank, IMF, structural adjustment programs, all that kind of stuff. At about the turn of the century, people started realizing that this was good. So I think it is getting better. But I also understand the hesitancy of some people or countries to be very cautious about this. Because if you say that water is a right for everyone, that's great at that level. But then if you look at a fur village in northwestern Sudan, whose well has just dried up, and that's permanent, that's not going to change. Now have you created a situation where now you must provide a water source to that village? So I think there's a qualification. What I wrote was, is water and sanitation human right? Yes, within framework of the environment and available human resources. Because that, I mean, you could be creating a massive monetary commitment if this was not couched in the right framework.
No, I think that's a very valuable point, and I think it's one that actually, we go back to sort of the earlier parts of the presentation around what does it mean in terms of enforceability. It's not everyone with water and sanitation in your hand today. It's really about, and when you see countries that are incorporating this into their domestic frameworks, you see the standard of reasonableness or of progressive realization. And so I think that is a challenging situation there, but I don't think, to me, in that scenario, you may have as an outcome, you may have those villagers perhaps using human rights, whether in the streets or in the courts, as a way of trying to bring attention and scrutiny to the government's actions. But that doesn't necessarily mean that the outcome is going to be that all of a sudden you need to be bringing pipes out to those places. I think the other interesting thing that you pointed out is, you know, the human rights language has been critiqued for being incredibly anthropocentric. And so in terms of being environmentally sustainable, that is not, you see the language of environmental sustainability coming in, and you often see, you know, certain documents, this language comes in, but one of the responses to that is that in most parts of the world, drinking water, and this is what we're really talking about here, drinking water is a very small fraction of total water use. And that a lot of times you see human rights language sometimes being used when people are concerned about their, say, irrigation water being contaminated or other things happening. And you know, that is an area where I think from a standpoint of international law, you're on much shakier ground.
Yeah, I think just building on that point, I've got sort of just two ideas, and that's this within this idea of the trade-offs between different rights, because because water is such an important part of all of the other rights too. When you're looking at a right to food, for example, is it actually better for us to put water towards irrigation rather than other things, because that's actually going to realize the right to food, or all of these kind of trade-offs about they're all equal, but they sort of you can differentiate between them, but they're all linked. And I think that one of the biggest things that comes through is this idea of financial sustainability linked to progressive realization in trying to make this trade-off. I mean, that's, knowing the South African case, that's exactly what it comes down to, is that, well, actually, this is where we can make it a little bit more financially sustainable for the state or whoever, so that we can focus on realizing some of these other rights, like healthcare, housing, which is not as easy to sort of get private sector, et cetera, involved and actually get people to pay for things. So, the efficiency, I'm not so sure I've got issues about the idea of efficiency as being like the optimal thing that we need to strive for in the first place. But this idea around financial sustainability, I think, is really closely linked to progressive realization of that concept and trade-off between different rights.
I think that that's exactly right, and I think that it's a really important area of future work, which is how do you, not just in isolation, look at this from a strictly legal standpoint, but actually think about this is really what are the macroeconomic factors that are in place. And there's a really interesting book by Mary Dowell Jones, which tries to link the legal with the economics, and then it actually critiques some of the work of the Economic and Social Rights Committee, because when countries are giving their reports and not having an understanding of what's actually happening in the country. And it's something that I think is, on the one hand, we all want to prioritize the issue that we care about, right? You have the person in front of you, and you want to help these people, right? But I think that it's a very valuable point to realize that these are embedded in a series of that all of these rights matter, and that is the way to progressively realize and achieve better water and sanitation by, for example, prioritizing housing, or creating some kind of jobs, because then people's livelihoods will be lifted, and then they'll be able to better realize it, right? I mean, I think this is an area that I think needs a lot more linking and further study, because oftentimes I think they're seen in opposition, when I actually think if you look at how these are framed legally, that shouldn't be the case.
I really am glad that you're not afraid to wade in these waters, because there's a lot of muddiness there, and I think policymakers really need new frameworks, and if you can articulate as well as you have, what are these other ways of slicing things. And one thing that I'm thinking of in the very long picture is what about the responsibility, not just of an individual government, but governments, like through whatever vehicles, to look at the source of water, which is affected by other actions that have ramifications. I mean, all the factors contributing to global warming are really generating impacts on the water supplies, and so that is going to require a whole another set. And I'm not sure where that's going to, where you can get the kind of, where you can introduce that into this, because you have this being looking at distribution, allocations, the kind of decisions that you make within a country. So you're going to have the border disputes, like you're taking on water, like Israel and Palestine situation, but then you're going to have Canada with its tar sands development, and what is it doing to world water availability? So have you thought about that next layer of introducing a scarcity, water scarcity on like governmental regulatory aspect?
Yeah, I mean, so touched on a lot of very, very important issues. I mean, I think everything that you were talking about from, you know, what's the situation with transboundary water issues and sort of political negotiations, how does, I mean, this, what we've covered today is really just one small slice of a much bigger question around water management and water management writ large, to include everything from, you know, agriculture, for industry, questions with natural resource mining or other kinds of forms, hydropower, and how other things around what's happening with the global climate, how that then intersects with the hydrological cycle. And I know there's a great talk the other day on that, everybody went to it. So, you know, I don't really have a good response to it, except that I think that from my standpoint, I do see value from a normative standpoint of human rights articulation, simply because I think it's a way of empowering people to actually think about how this, what rights they might have and how that might lead them to perhaps hold their governments more accountable. Because I don't, you know, although I think that there's a lot of good efforts out there, I think it's also really hard. I think a lot of states are struggling to figure out how to do this. And I do think, to that point, the new, I have a lot of hope and enthusiasm around the new guiding principles for business and human rights, because I don't think this is really just a situation of states alone. I mean, I think that the private sector has a huge role to play, and to the extent that they are cognizant, to the extent that their actions might be leading to poor water quality or groundwater depletion, and how that might intersect with livelihoods and kind of a greater, more broadly, corporate social responsibility, I think, you know, I'm hopeful.
But would that be, what they do, would it be parallel or using the same language that a government would have in one of those agreements with private sector? Like, you're saying that practices of business, where would they be the ones with that language rule more than the government language?
No, so I think if we go back to kind of the framework of protect, respect, remedy. So it's not that, I think that they were very careful to say that corporations do not have the same legal obligations as states. They are not parties to these treaties, they are not actors under international law per se, but they play an important role in sort of global governance. And what I think is valuable is that this language around ensuring that, so looking at water and sanitation specifically, and here we're really talking about drinking water and sanitation, but ensuring that it's available and accessible and affordable and clean and acceptable, and that there's non-discrimination and opportunities for participation. I mean, sort of the whole human rights panoply, that language ideally would then intersect with this, with the idea that you need to respect human rights. And so that looking at doing things like engaging in, you know, if Coke is going into a new country and is going to be building a factory, as part of its assessment, not only looking at the environmental sustainability for its own plant, but also considering how might its actions in terms of tapping into a particular aquifer impact the livelihoods of the people there. And so that might be of both the drinking water and sanitation, but then, as you point out, all of the other rights, right? And so thinking, so there's nothing like binding about this, though. I mean, that's one of the, but I think that there is this kind of norm creation, and that you have some companies that are leading the way, and that it's really about not just top down, but this language of kind of shared value. And I think so anyway, that's kind of, I don't know if that means anything to you guys, but it's a kind of an idea that's about businesses not just thinking about achieving these values through top-down regulation, or just through kind of compliance mechanisms, but also thinking about how a business can actually embrace these values and think about streamlining its own operations and meeting its own targets while also doing good.
Sorry, I had a comment on privatization and followed by a question.
Yeah.
But my comment really was, and I'm coming from India where I've done some research in water, but like, so where private sector has been successful is more like management contracts, and one, because they're easier concessions to frame, and second, because there's more acceptability about how efficient private sector is in managing water, but not owning the infrastructure. So when you divide like management and ownership, private sector has more acceptability in communities. I mean, it's a slow process, but like, and there are successes where, there are instances of success where management contracts have been able to introduce efficiency, and there hasn't been large mass protest. But another interesting thing about private sector is that they're also successful if they're able to cross-subsidize, and that cross-subsidization is advertised, that people are aware that the industry is paying a part of the high infrastructure costs. For example, like there's a city in Delhi, Jamshedpur, where like they're using, or like the successes in India where private sector is involved, they've kind of they supply water to like industries and also households, and that's like a model in the private sector that's been successful. So they charge higher to industries, everybody's aware about this, and then that generates acceptability.
In terms of the tariff structure?
In terms of tariff structure, yeah. So you're charging higher from industries. In Tirupur, it's like the water, it's like the clothing industry, and you know, and then you're using those profits, those surpluses, as I'm calling them profits, to kind of subsidize the water that's going to households. That was my comment on privatization. But my question is that I feel like because of like the arguments around rights has really focused on pricing and privatization, but I feel like it kind of these kind of arguments lead to less emphasis on these traditional approaches to water, like rainwater harvesting, and I feel like that should be the center of all discussions instead of should we privatize or should we not. It should be, let's focus on rainwater harvesting, and also like I feel like in this and the reason is because on these tables where these arguments are happening, you don't have people from these multidisciplinary backgrounds. You have a lot of economists now, and you have people from legal backgrounds, but I don't know how many people here, I don't understand geology, or like, how many people understand ecology, and I feel like that's what's lacking, and I feel like that's why we're not getting the solutions that we would otherwise reach.
So I would actually point you to the work of probably Karen Bacher, who's done a lot of good writing on, and there's a new book by Farhana Sultana and Alex Loftus as well, but that basically look at this, right? I mean, there are geographers and political ecologists that are basically saying, alternatives, that there's commons, not commodities, and looking at these kind of more traditional ways of managing that is without the state. At the same time, I think that depending on where you are, there's also recognition that sometimes there's a romanticized notion of kind of traditional ways. Like, it is hard, in many parts of the world, like, it is hard work gathering water from a well, or, in certain places it may make sense, it may be part of your cultural tradition, but in many parts of the world, people want to have easier access to services and not have to kind of invest the amount of time and effort and energy that it takes. I think that's, I think all these points are valuable, and we could probably have a whole day just on all of these different topics, because this, as I said, is really just one slice of the larger piece, and it was really my attempt to kind of grapple with why is it that the human right to water was such a rallying cry in privatization, because if you look at the literature, that's what comes up, right?
Yeah.
But then how does that then sit with this whole idea of human rights being neutral on the question?
Yeah, just on that topic, you sort of sparked an idea in my head, which is it's quite fascinating, because at the same point as you have a rights-based sort of discourse being very empowering, it can also take it can also be disempowering in the sense that, and you see this happening a lot in South Africa, not necessarily in the water sector, but if the state has this obligation to realize this right, I no longer have an incentive to try and realize this right for myself. And so all of that, that ingenuity, that idea around communities coming together to try and rectify a problem, which within sort of nodes of like the romanticized idea of communities, can be more environmentally sustainable, can be actually working within the resources that you have rather than relying on sort of outside help coming in. sort of it detracts a lot away from those processes. And so it's how do you try and reconcile both of those and encourage and say that the human rights include that process of, well, actually it's not just about, and sanitation is important in this instance, you know, this idea around, well, sanitation is actually about having flushing toilets, when at the end of the day, maybe it's actually not, but people kind of see that if the government's not putting these in place, it's not realizing my rights, but meanwhile there are a lot of other different ways of doing it, and so there are a lot of tensions that actually, and I think that the point you raised around that was really important and needs to be tackled a bit more.
Yeah, I mean, as I said, that's why empirically I'm very interested to examine the influence that it has, because, you know, there's often as well kind of rights in the way that you articulated them, but then also people will say, thinking about water rights, so not the human right to water, but water rights, and using kind of rights language and property can actually entrench existing relationships and existing uses. And so I think, as I said, from the standpoint of a normative standpoint, I see value in this. But has this really been productive on the ground? I think we can look at different case studies. I think trying to make a broad assessment is actually quite challenging, just from the standpoint of, are there enough examples, and could you actually get access to all that data?
Something you touched on, you showed the picture of the crowd, and something you just mentioned, and you did as well, is the collective responsibility to provide basic goods. And when I was listening to you, I was thinking, prior to your question, of my village in Wisconsin, 4,000 people in western Wisconsin. We, 5 years ago, replaced our municipal well and our standpipe, which is quite an undertaking. The original system was raised completely by the village back in the 1800s. There was no state input. When we did this 5, 6 years ago, there was no state input. It was all agreed to by the village board. And so when you look at that, there is a collective responsibility there to do that. Little village in Nicaragua, El Corral, we gave them a plan to bring surface water from above where their cattle were grazing and where they were having problems. We left them the pipe. We showed them how to lay this and do all the work. 5, 6 years later, I went back. The pipe had all been stolen and cut up and used for different things. In other words, there was no apparent collective responsibility. They could have solved their water problems for the next 20 years with a very simple and small project. That they could have done on their own. Didn't require any government aid. You know, we've given them everything they needed. No government aid required. The maintenance would have been minimal. But there was no collective. So there's a cultural aspect to this too. That even if you privatize or don't privatize, and you provide these systems, where is the collective responsibility?
Yeah, I mean,
How do you inculcate that?
I think it's a topic that, you know, the whole sort of realm of like sort of participatory development, and how do you actually identify projects that make sense for communities and have their input and try to build this, right? I mean, there's lots of people trying to sort of grapple with these questions, and I think some lessons learned that have sort of filtered up about what works and what doesn't, and I don't know enough about the examples you gave to comment on them, but I think, you know, listening to both your comment and your comment, Laura, is, you know, one of the things that, although this did focus really on kind of the kind of traditional formal private sector, I think one thing that I want to kind of leave you with is this idea, though, that state responsibility doesn't necessarily mean state has to provide it, and that, you know, in many ways, you know, if we go back to, so Karen Baca, who I know you know, has this metaphor of using of an archipelago, and that in many parts of the world, people aren't relying on just one network pipe. They are relying on, you know, the tanker truck, the water vendor, the bottled water, maybe a little bit of filched water from here or there, and there's kind of an archipelago. And I like to talk about this normative network goal, that from a normative standpoint, we want everybody to have networked water. But I think the reality is that in my vision of how I'm sort of conceptualizing this is that human rights in some ways is about how do you sort of strengthen the bonds that are between that sort of the archipelago? How do you sort of move it more closely to this kind of normative ideal of everybody having easy access to safe drinking water and sanitation in a way that was respecting of local conditions and ideally environmentally sustainable, right? I mean, how do we sort of move towards that? And are there things, whether it's, not, even in the example in Wisconsin, I don't know enough about that, but were there certain like tax incentives or various things that were in place that sort of allowed that community, or even public health regulations? We often see this kind of mismatch in terms of even people trying to do things and finding out that, they have to jump through 10 million hoops or it's not allowed. And so how is it that we think about these kind of progressive realization and human rights as guideposts to this without saying this equates with the state giving me a toilet and a tap? Any more final thoughts? All right, thank you guys for coming. I really appreciate it.